Hello, everyone. Thank you for your attention. I'm Heng Wang from UNSW Sydney. I'm also a professor and co-director of Herbert Smith's Freehills China International Business and Economic Law Center at the UNSW Law and Justice. Today, I'd like to talk about the central bank digital currency and private international law. The key question I would like to discuss is that what are the private international law implications for central bank digital currencies? If we look in, I will first look into introduction, explaining what is the CBDC, and then look into the case study of ESNY. And based on that, I will look into the issues that we may face regarding CBDC and private international law. And then we'll analyze what are the opportunities and challenges for private international law and CBDC before I conclude. So firstly, let's look into what is CBDC. What is CBDC? CBDC is basically a digital version of the fiat currency. It's central bank's liability and supported by the central bank credit. And also the second question you may have is that what is the relationship or what's the difference or common points between CBDC and cryptocurrencies and stable coins? So on one hand, we know that there are common points. So for example, CBDC and cryptocurrencies or the stable coins, they are all digital currencies. However, there are obvious differences because CBDCs are issued by the central banks and the like. It's a public money, while the private, cryptocurrency and stable coins, they are issued by the private entities. They are private money. In other words, central banks is public institutions, while cryptocurrencies are not issued by public institutions like central banks. The third question I want to explain here is that who are the actors of CBDCs, particularly retail CBDCs, because retail CBDC are widely explored by many central banks. So here, if we look into the CBDC, they could have, retail CBDCs, which means that they can be used by individuals and the public, including firms. In contrast to retail CBDCs, there are also wholesale CBDCs, which are largely used by, commercial banks, selected financial institutions, but they are not used by, the general public. So that's the wholesale CBDCs. If we look into the retail CBDCs, the actors are central banks and the users, firms and individuals, intermediaries, because, often central banks rely on commercial banks, for example, to help distribute CBDCs to the individuals. And of course, we also rely on technology and infrastructure firms and so on and so forth. The fourth question we can ask here is that who are the major dimensions for us to understand CBDC? I would like to see that at least there's three dimensions. One is infrastructure. So think about CBDC as a kind of infrastructure for payments. It's a ecosystem, because you have to use, like the retail CBDC in different aspects of society as a fiat currency, as a legal tender. And also is infrastructure, regarding payments, data related to CBDC and so on and so forth, including software, including hardware like devices. And of course, another dimension is technology. You heavily rely on technology, to deal with many issues like cybersecurity, technical standards, and the interoperability with existing systems. Obviously, they also have regulation. That includes how to comply, with domestic regulation like know your customer. And another example for regulation includes foreign exchange, data sharing, competition, and possible limits on CBDC use, for example, to combat financing of terrorism. The final question here is about what are the potential use cases So they may be used for finance, trade and digitalized commerce. Think about, machine-to-machine transactions, because CBDC can be used for, smart contract, which is a computer program, computerized program to make payments, automatically if the preset conditions are met. And also they can be used for international remittance. Now, let's look into our case study, a concrete example like China's ECNY, China's CBDC. The reason why we choose China is because China is one of the few countries which has explored CBDC and including pilots programs in that regard. And China is likely to be the first major economy to issue CBDC. If we look into the ECNY, they have tier 1, which is the central bank, People's Bank of China, which issues ECNY. And then you have tier 2.0 or tier 2, which are a smaller number of operating institutions, large state-owned banks, internet banks, and telecommunication companies working with these banks. They open ECNY wallets and they disseminate ECNY and take responsible for know your customers and also equipments or devices for ECNY. And then you have tier 2.5 below that, which provide services to ECNY users. The tier 2.5 institutions often work with tier 2.0 institutions to get access to the ECNY. The final one, you can call it a tier 3. It's end users, they're businesses and consumers who use ECNY, thinking about international firms, with presence in China, like the, fast food chains, and so on and so forth. I hope this gives you an idea of the, how CBDC operate. Obviously China is working on pilots, including offline payments. And also China is working with, BIS Innovation Hub, central banks in Thailand, and UAE and so on and so forth to have a project on MCBDC bridge, try to explore how different CBDCs may be linked. And also China has established a joint venture with SWIFT, which may support, digital currency in the future if everything goes smoothly. Another example we can look into, the practice of CBDC is Bahamas sand dollar. It has been launched for domestic use, but also they are exploring on offline, payment capabilities with card network company. For example, including CBDC being allowed to be uploaded to physical cards. And there are many other states, exploring CBDC, including, Sweden, which are working on the CBDC projects, and also you have countries like UK, and also economies like Euro, exploring digital euro, and also US is looking to potential digital dollar, and also in Asia, Japan, Korea, Singapore, and so on and so forth. And also international organizations and various stakeholders are involved, including, HCCH, BIS, IMF, World Bank, as well as, G7 and so on and so forth. Now, let's look into the specific issue regarding the CBDC and private international law. I think there are at least a number of issues that deserve attention. One is that, devices. What does it mean? It means that actually CBDC, rely on digital wallets. And it's quite different from the cash, where you don't really need a digital wallet. You can use cash and then spend it. While in the CBDC, it's quite different scenarios. And that involve many legal relations regarding, how do you open digital wallets, how did it operate, and so on and so forth. Another unique aspect of digital currency, CBDC here, is about digital identity and also data that involve data flow, data regulation, and also big data. How do you use the data. That also may like to trigger private international law issues. And the third one is that, is the retail CBDC, as mentioned earlier, vis-a-vis wholesale CBDCs. They may operate in different contexts, and their operation will be different. A fourth dimension or issues is about whether the CBDC is account-based one, rely on accounts, or it's a token-based CBDCs. That may involve issue like, whether you are treat them as a tangible or intangible, and that will have implication for private international law. And if we look into more broadly at technical designs of the CBDC, you have issue about programmability, smart contracts, offline capabilities, and there are also many issues that deserve attention in private international law, such as, how do you deal with a breach of the smart contracts, which law will apply here, and so on and so forth. And also they have an important issue about interoperability. That means CBDC does not live in a vacuum. It will be linked with existing, legacy financial system. And also they may have interoperability among CBDCs. And that also may involve the issue about, how do you decide the applicable law or jurisdiction, and so on and so forth. And last but not least, there are more technical or detailed issues that are crucial for private international law in the CBDC context. For example, what are the locations of the different actors, because CBDC has so many different actors ranging from central banks, to private sectors like, intermediaries, commercial banks, retail firms, and as well as individuals. These are also very important in trade, cross-border economic transactions, e-commerce, to decide private international law issue. Now, what are the opportunities and the challenges for private international law and CBDC? Obviously, there are many opportunities, for CBDC and also for private international law, because if everything goes smoothly, if CBDC address, issues like privacy protection, for example, cybersecurity, if CBDC progress smoothly, we are like to see a CBDC ecosystem, which means that they may be widely used by businesses and individuals as a legal tender in the economy. However, another side, there also may be, potential disputes arise from the CBDCs. Thinking about smart contracts, if there's any glitch or issues with the design of smart contracts, then how do you deal with those disputes? Which law will apply? And also another example is the insolvency of participants, like commercial banks. What happened if the intermediaries for the CBDC system and they face customers? However, if one day they become insolvent, how do you deal with that? Which law applies? And also another that relates to issue about consumer protection, fraud, privacy, and also another example is the settlement finality in offline payments. So here, if we look into the private international law, the number of aspects you have to focus on. One is that how do you decide connecting factors? Different states may have a different design, as I mentioned earlier, for the CBDC, or different operation, different incentives and public policy on CBDC, and that may affect connecting factors and how a court, for example, decide those issues. And also it's important to look into the party autonomy in choice of law and its possible limits. So think about if CBDC is used in international commerce, how do we permit party autonomy? How do we set a boundary for that? And to what extent, the party autonomy may be restricted? For example, CBDC's use may be restricted if there's, fraud and other circumstances. And also, here is another issue about jurisdictions. What are the jurisdiction of the courts? What court will deal with that? To what extent? And that also, again, relates to intermediaries, to the parties, to their system. And obviously, you have issue about governing law. dealing with many issues like opening CBDC accounts, wallets, holding transactions, payments, settlements, and data flow. So these are many new issues that deserves private international law rules. And last but not least, recognition enforcement in CBDC systems involving, interoperabilities, and also involve issue like if you have a judgment relating to CBDC, whether they will be recognized and enforced in different jurisdictions, because different countries may have a different approach to CBDCs. Some of them will issue that, some of them will wait and see, and some of them may not want to go down this path. To conclude here, I would like to see that actually for private international and CBDC, there are pathways. Obvious one way is to adapt, old rules to CBDC. Another one is that to adopt new rules, develop new rules of private international law to deal with CBDC. It remains to be seen that whether there's a critical mass, and they may help to forge a group of countries on particular private international law. They may also have a network effect, attracting more states to join this direction. And secondly, it's important for private international law and CBDC to balance between flexibility and predictability. So CBDC is obviously a moving target. Think about technology, keep on evolving, as well as regulation. They may respond to the problems or challenges in CBDC operation. On the other hand, the CBDC design and regulation, may also evolve over time. And here is the issue that on one hand, you want to avoid fragmentation because that will be very difficult and challenging for transactions that are too high cost and also not helpful for innovation. So on another side, you want to make sure that predictability while maintain flexibility. And thirdly, it's important to carefully think about the role of the state and the market, including party autonomy, because obviously CBDC is a state issued currency, and that involves many public policy objectives, including financial stability to market integrity, and that may affect private international law issues. On another hand, you want to ensure that you support the role of the market and also the party autonomy, and there ensure the trust which will be in the CBDC system. That will be very crucial for CBDC's operation. So transparency and any other aspect of that will also be relevant to make sure that CBDC is widely accepted or has a the general public has a confidence in that. And also it's important to look into the private international law issues. Use a forward-looking approach. We should not wait until CBDC put into practice. We need to think about private international law issues in advance to make sure that they are working smoothly, and otherwise they will be difficult to be used for international commerce. Finally, I think international cooperation is really crucial because CBDC may have intended and unintended effects, and different countries have different approach and consideration, and international organizations will be very important to narrow the gap and provide a venue for negotiation, discussion, and exchange of the best practice. However, it won't be an easy job. So they need a lot of inputs, they need a lot of transparency, they need a lot of the confidence and also exchange of information in that regard. So with that, I would like to stop here and thank you very much for your attention.